As between civil and criminal matters, access to witnesses and to physical evidence operate under different rules. The discovery rules that are fundamental to civil litigation are absent in criminal matters. In a civil case, both parties must be prepared to give testimony or face an adverse judgment by default. In a criminal case, the defendant need never testify, and the fact finder should draw no adverse inference from her failure to do so. In a civil case, any party may make requests for production of documents and inspection of things within very broad bounds, so long as there is a basis for believing the requested matter is or might lead to further evidence as to any material fact. Counsel for each party must be reasonably diligent in responding to another side's lawful requests. On the criminal side, the prosecution may make reasonable searches and seizures, but it may not request incriminating information from the defendant. Physical evidence that comes into the possession of defense counsel presents an exception, which we covered in an earlier installment. The prosecution, on the other hand, has to be forthcoming. According to Model Rule of Professional Conduct 3.8d, the prosecutor in a criminal case shall make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense, and in connection with sentencing, disclose to the defense and to the tribunal all unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved of this responsibility by a protective order. Another important special duty of prosecutors has to do with their exercise of discretion. In American systems, prosecutors decide whether charges will be pressed or dropped, and which charges are pressed and which are not. Because prosecutors occupy an elective office, they are susceptible to pressures to be tough on crime. Prosecutors may be tempted to throw the book at the defendant to apply pressure to plead to a lesser offense. The charging decision is essentially unreviewable. The U.S. Supreme Court has held that, as a matter of due process, so long as the prosecutor has probable cause to believe that the accused committed an offense defined by statute, the decision what charges to file generally rests in his discretion. Probable cause is a very low threshold, somewhere a notch above reasonable suspicion, but not nearly as high as preponderance of the evidence, much less proof beyond a reasonable doubt. The ABA has promulgated standards for criminal justice that set the bar significantly higher than the due process minimum. The ABA standards for criminal justice provide that a prosecutor should seek or file or maintain criminal charges only if the prosecutor reasonably believes that admissible evidence will be sufficient to support conviction beyond a reasonable doubt. Compare the duties of attorneys on either side of civil litigation. The only limit is no frivolous actions or defenses should be maintained. Furthermore, a prosecutor's office should not file or maintain charges if it believes the defendant is innocent, no matter what the state of the evidence. In a civil action, an attorney need not abandon a cause she believes ought legally or factually to fail. A prosecutor has special obligations in plea negotiations as well. A prosecutor should not knowingly make false statements of fact or law in the course of disposition discussions. Under Model Rule of Professional Conduct 4.1, lawyers are already generally forbidden to make false or misleading statements of law or material fact. But recall that comment to the rule. Under generally accepted conventions and negotiations, certain types of statements are not taken as statements of material fact. Estimates of price or value placed on the subject of a transaction and a party's intentions as to an acceptable settlement of a claim are ordinarily in this category. This comment to Rule 4.1 applies in negotiating a civil settlement. A prosecutor may not invoke it to justify tactics in plea bargaining. Furthermore, a prosecutor should not agree to a guilty plea if the prosecutor reasonably believes that sufficient admissible evidence to support a conviction beyond reasonable doubt would be lacking if the matter went to trial. This is much more constraining than the rules that apply outside the criminal law context. A plaintiff's lawyer who thinks she's holding a losing hand but gets the other side to fold should pop the cork and pour the champagne. But the prosecutor in the parallel position should be ashamed of himself. Note, though, that this doesn't mean the prosecutor cannot accept a plea unless she thinks he would win at trial. What it means is that the prosecutor should not accept a plea unless a reasonable jury could convict. However, the prosecutor must make his assessment based upon the evidence he reasonably believes he can get in. Illegally obtained evidence, however damning, must be set aside in the prosecutor's mind. The question, in effect, is whether a guilty verdict would survive a challenge to the sufficiency to the admitted evidence on appeal. If the defendant wants to plead, but the prosecutor believes his key evidence will be excluded, then he cannot accept the plea under the ABA standards. Litigators in civil practice get to treat negotiation like a game of poker and delight when they win the pot by bluffing a bad hand. The slyer the theft, the sweeter the honey, as somebody once said. Prosecutors ethically cannot adopt this attitude. We do not have the time to survey the many other rules pertaining to criminal justice. One more general rule should be noted, however, having to do with forensics. Trial attorneys have to remember that their role is a representative one. They are not witnesses, except in narrowly defined exceptional circumstances, and they do not want to be subject to being called as witnesses. A lawyer shall not in trial assert personal knowledge of facts and issue except when testifying as a witness, or state a personal opinion as to the justness of a cause, the credibility of a witness, the culpability of a civil litigant, or the guilt or innocence of an accused. The lawyer, as advocate, has to walk a fine line. She must persuade the court and the jury that the facts and the law demand that her client prevail. But she may not assert personal knowledge. She must instead speak of what testimony and other evidence will show or has shown. Moreover, she may not state her personal opinion as to the credibility of a witness or the guilt or innocence of an accused. Consistently with what the fairness rule states, the most effective trial advocates manage to convey a sense of conviction without outright stating or asserting them as personal knowledge or opinion. The important thing is that the advocate never intimate or suggest that her conviction is based on something other than record evidence.